order, and I looked at the bottom and said, these two items will be mailed to you. I'm like, you're mailing me a bag of Fritos?
It's a pleasant gift, it's better than bills.
Sure. So just for future reference, I'll be able to, order food from Walmart if I need it. If I'm on a trip and want to order something for my dad, he can drive, because the Walmart is literally around the corner. When the leaves are off the trees like now, we can stand in our front yard and see the lights of the Walmart, the sign on the front of the building. It's that close.
We're not that close. We have to drive a ways. I think there's an attendee in here.
I'm trying to get.
Is there?
Is that Mr. Ball?
It is, but I can't get it to work, man.
That's our friend here. It is.
It's me, but it ain't working.
All right. I'm gonna hook him up.
I'm gonna go ahead and go on mute because it's live.
Okay.
Outside my door.
Thank you for noticing that.
Can y'all hear me?
Mr. Baxter, are you with us?
I'm trying certain.
I just moved you from being an attendee to a participant.
Is it letting me in?
I can hear you fine.
You can
I'm
hear
not
me.
seeing a
I'm
picture,
I'm trying to get the. For some reason, my web camera ain't coming up. Won't come on. I'm looking at it now to see what's going on with it.
though. Okay,
There it come
we'll
on.
get into
There
that.
I am. Can y'all see me? I see myself, anyways.
No,
Or
I
let me
see
see.
you now.
Maybe let's see. As soon as I can get this, keep that setting.
There's a setting on this program that has a little picture of the camera. Make sure it doesn't have a slash across it. Click on it and it'll show the video. Let you show the video.
Say that. I say it says our camera's off. That's all. Wait a minute. Here we go. Maybe I found something.
Okay. There you go.
Oh, come on. Oh, hey. Hey, how you doing today? Good morning. Good morning.
All right. Well, of course, before we go on the record, what we're here to do today is a pretrial hearing. It is not, a full-blown hearing on the merits where you present all your evidence and all of that stuff. It's just to deal with pending motions and see what happens with those. And if the case goes on, then of course you'd have to come up with a discovery order to set the schedule for the case, ongoing down the road.
Okay.
So everybody can hear and see and everything okay. It looks like we've got a good connection. If something happens and we lose our connection or you drop out, just try to go back out of the system and come back in. That's what I'll do if something happens. So it might take, 3 or 4 or 5 minutes to do that, but just, that's what to do if something drops out. Of course, if we're going along and you can't understand something or you didn't hear something, sometimes we do get some audio drop out or some sketchy sound here and there. If you didn't understand something, let us know and somebody can repeat what they said, or you can ask the question again, or whatever the situation may be. With that, is there anything to address before we go on the record and get started? I don't think so.
I believe so.
Okay. All right. Then, Madam Court Reporter, if you'll go ahead and get us on the record, please.
You're on the record, Lord.
All right, and I'm gonna hit my button to record on my end. Okay, we are recording. Good morning, my name's David Marcon, I'm the Deputy Commissioner of the North Carolina Industrial Commission. Today is Wednesday, February 9th, 2022, and we're here on the WebEx system to conduct a pretrial hearing in the tort case that, is case number TA 29211, Travis Wayne Baxter, who appears pro se, versus North Carolina State Highway Patrol Troop F District, represented by Christopher Brown of the North Carolina Department of Justice. As I said, we are here on a pretrial hearing in this court matter. The defendant does have pending motions, so I'll let the defendant go ahead and address those motions, and of course, once they get through, Mr. Baxter, you'll have an opportunity to, address those as well. So, Mr. Brown?
Good morning, thank you, Your Honor. So I'll begin with, what we labeled as our total fee one and two motions. In the motions to dismiss, it does include intentional tort in the title, but it does, generally the motion is for, jurisdictional, issues with the, type of claims that, Mr. Baxter has brought here. Those being claims based in intentional tort and claims based in constitutional right violations. Beginning with the intentional tort, the Industrial Commission, doesn't have personal or subject matter jurisdiction over claims involving intentional tort. Section 143-291 of the North Carolina General Statutes, states that, the Industrial Commission shall determine whether or not each individual claim arose as a result of the negligence. And that very clearly states negligence. So, the court of Bradwell has gone on, and interpreted that to mean that injuries intentionally inflicted by an employee are not compensable under the Tort Claims Act. If you review and reference plaintiff's affidavit, you'll see that he includes allegations of coercion, malicious injury, conspiracy, attempted murder, trespass, assault. To the extent those are actions of the court, they go above and beyond, the negligence that is within the jurisdiction of the Industrial Commission. They were clearly couched within intentional tort. They require intent to have been committed, and, by pleading those, Mr. Baxter's, affidavit is fatal on its face, based on what has been presented to the Industrial Commission in that affidavit. And you'll note that he says that it is a foreseen, necessarily means that the truth is intentionally did or illegal. And so that alone, the intentional tort, defendant would contend is sufficient to have Mr. Baxter's affidavit dismissed, with prejudice as to those claims. Moving to the constitutional jurisdictional issues, again, the Industrial Commission only has jurisdiction over claims based on negligence. The court in Medley, discusses that distinction between a constitutional violation and a negligence claim. And there they parsed out that distinction. So negligence claims and constitutional claims, are distinct, and, the Industrial Commission only has jurisdiction over those negligence claims, and constitutional claims must be dismissed. And, Mr. Baxter's affidavit mentions an unlawful search and seizure, as part of his claim there, that clearly on its face, indicates a violation of constitutional rights, or attempt to make a claim based on violation of constitutional rights. Taking the issues with the intentional tort and with the constitutional rights violation claim, there doesn't appear to be anything left within Mr. Baxter's affidavit to allow him to proceed on any recognizable or investable claim by the Industrial Commission. There was also a motion, based on statute of limitations. Section 143-299 of the North Carolina General Statutes states that the statute of limitations for claims to be brought before the Industrial Commission is 3 years. Plaintiff is alleged of conspiracy, again, which is an intentional tort, not redressable by the Industrial Commission, but he's claiming that it's 20 years. Anything that is older than 3 years, from the date of when he filed the affidavit, is not a claim, even if based on negligence that he could bring, at the time. So to the extent that plaintiff is alleged to claims that predate the filing of his affidavit on, February 26, 2021, by more than 3 years, those must be dismissed. Baxter has failed to state a claim upon which relief can be granted. And defendant has made a 12B6 motion, as such. The court in Simmons, lays out the elements that a plaintiff must prove to recover based on negligence. He must show that defendant owed him a duty of care, and that the actions of failure act by the main state employee breached that duty. The breach was the actual and proximate cause of the injury, and that plaintiff suffered damages as a result. In reviewing Mr. Baxter's affidavit, he uses the term negligence almost in passing. It seems almost to just be thrown in there. He doesn't give any causal link between the defendant employee's actions and the resulting damage. And once you remove any of the language that involves intentional tort, constitutional claims, or otherwise barred by exceptional limitations, there's nothing left for Mr. Baxter to base the claim of negligence on. So that simply fails to state a claim upon which relief can be granted. And again, the damages portion, when you read that, only describes intentional tort. So even if you said, even if, assuming arguendo that he has somehow satisfied, the parts of the elements that get into damages, the damages that he specified are all intentional tort claims, which again are not, addressable by the industrial commission. So those are our motions to dismiss. If you'd like, I can address now plaintiff's motion for default. If you'd like, if you prefer for him to go first on that, that's certainly fine. But that is all that I have for our motions to dismiss.
Well, I guess while you're going to go ahead and address that, I'll let you go ahead and address that one.
Certainly. Mr. Baxter's affidavit was filed on 26th February 2021. That affidavit was received by defendant on 22nd March 2021. And the proof of service that was generated would indicate the same, and it was included as Exhibit A on defendant's response to plaintiff's motion for default judgment. On 21st April 2021, defendant filed his motions to dismiss, and those were based on Rule 12B motions, arguing that plaintiff alleged intentional torts, statute of limitations, constitutional violations, and failure to state a claim upon which relief can be granted. At the time of plaintiff's motion for default, those motions were still pending. Our defendant's motions for dismissal were still pending. On the 19th day of April 2021, plaintiff served a motion for entry of default. Again, at that time, the time for defendant to respond or otherwise answer had not expired. And so that motion for default was premature. Defendant did respond to plaintiff's claims within 30 days of service of the affidavit as required by Rule 12. And if you'll note, if you review Rule 12, it states under A1 that service of a motion under Rule 12 alters the time period for answering unless ordered by the court. The court in Mosley goes on to state that filing a 12B motion postpones defendant's due date for answering until determination on those motions. So based on those facts alone, plaintiff's motions to default should be denied as untimely. And moving forward, assuming that it was timely, Rule 55 of the North Carolina Rules of Civil Procedure, under which plaintiff can request default, states that no default shall be entered against the state unless the claimant establishes his claim or right to relief by evidence. That is, no evidence has been presented to establish his claim or right to relief, so it would be improper for him to default as requested by plaintiff.
All right, thank you. Mr. Baxter, I'll let you, respond to those, as you might. Why don't you respond to the default first and then, the other second, if you would, please.
Okay. Thank you, sir. Good morning. My name is Travis Baxter. Yes, sir. I filed the default after I'd placed the complaint in the industrial commission. The default judgment. I stayed in contact with the clerk, Paula, the entire time, as that way I can keep up with the 30 days, as you know, to go with the rule. As far as getting my 30, they had 30 days to respond. Well, it got up into about 40 some days, 45 days, and was no response, and that's when I contacted Paula, and she had told me what day to file it, and I'd done filed the default thinking I was on time, but really I was 2 days early. I'd filed it on day 28. And therefore, the state had they had a 2 days notice still to get any kind of motions in place. And instead, what happened? That there's a paper that got turned in, and it's a penciled in paper that was hand delivered. And I know Paula told me herself that this stuff was emailed over or faxed. It was faxed over as well, but that's not showing in the record. What's in the record? From the state is a handwritten paper, and you can look down through the file numbers, and it's in order. It goes 5, 6, 7. It's almost like they just backdate it, and at the very end there's a 44. It goes all the way up to 19 and skips from 20 all the way to 4. It skips 20 to 43 and it jumps to 44. This paper here was designed to put the state back into within their 30 days. But what the state didn't take into account was the Black's Law Legal Dictionary. They still are in default. It's 31 days, according to the Black's Law Legal Dictionary, where today don't count as day one. Tomorrow would be day one. And it still, like I said, it still puts them at 31 days. And as far as their response to the motion of default, where I did file, it's untimely. The canon law of North Carolina, 11 NC Admin Code 23B.0204 Part G. They only have 10 days to respond. They from the 19th to the 5th of the month in question, or the month we're talking of, 19th to the 5th is more than 10 days. So this response, even on my motion for default, is untimely. The state failed to answer according to the civil rules of procedure. They didn't answer within 30 days. They answered within 31, even if you take into account their fraud, pencil in transfer of documents. But that was, like I say, even their response was also untimely as well. I named an amount certain in the claim, and like I said, there was amount certain, and like there should be default on the state. That's about all I have to say about as far as the default goes. But if I can go on, Your Honor,
Go ahead.
what I filed, Mr. Brown's alleging that my complaint has no negligence. First of all, conspiracy, tort law was derived around conspiracy, or the word comes from torture. Conspiracy is the oldest tort, and it's the oldest tort there is. There is 5 negligent, or there is 5 intentional torts, and conspiracy is not one of them. Although the statute does not say anything about it, as far as the Industrial Commission section of the General Statutes, nowhere in there although that has been ruled on, and that's countrywide, that intentional torts are not, that's not the Tort Claims Act. But as far as that goes, conspiracy is not an intentional tort. And the negligence, I've said from the get-go, the negligence comes from the handcuffs. It's all about breach of procedure, or breach of what they were trained. It's the tort acts. The state has an obligation, and they're whatever that obligation may be, and there's a breach, and therefore there's an injury that comes from it. And like I said, the handcuffs falling off, the evidence was turned in. Also the common law case law, the Parker versus DOT, I turned in. That's a default case to where that what come up to question was how the state can't be caught in default, because it is unclear in the statute. At the very bottom, there's an exception at the very bottom that addresses the state being in default. But as long as you turn in evidence, proving your case, and like I said, there's a picture of the handcuff being open. A handcuff cannot come open unless a handcuff can't come open once put on correctly. There's a picture of the handcuff, and then there's a picture of the taser that went on for over a minute. and even the double shock, you can see where I go unconscious. You can see my muscles go to flaring. And also the other officer even gets electrocuted. You can see when he grabs hold of the handcuff at one point, and you see him jerk his hand back where they kept shocking me. But in the whole time, other than while he was sitting there taunting my daddy, but his knee was pressed into the back of my spine on my lungs, squeezing the air out of me, while getting electrocuted. You know, and an emergency personnel would be trained if they're going to perform CPR. They're trained to breathe air back into your lungs and get your heart started back. The electrocution, like I said, that's a shock hits the nervous system between the brain and the heart. It can stop the heart. The troopers are trained on what it's sudden death of a. Well, it's positional asphyxia, but it's sudden death in custody, I believe is the way it was referred to. But anyways, they're trained on ways to basically keep from killing people if they use any kind of force, whether it be lesser force or a deadly force, whatever. The deadly force being they're authorized to use deadly force, but that's in the extreme circumstance. Here it's obviously that everything was over. It was over. I mean, it's just overdone. It's overkill. I'm laying there unconscious. He's got his knee pressed to my back. I'm unresponsive. And then still, like I said, I'm so limp. You can see you see the muscles flaring. But I'm alleging. Like I say, the conspiracy is not a intentional tort. The intentional torts, I don't know if I can name all 5 of them offhand. But it's battery, assault, and it's been a while. But there's 5 intentional torts, and conspiracy is not one of them. And like I said, the canon law, everything the state's done in this case, everything right down to the Department of Justice getting this case, everything they've done's been negligent. Like I said, this entire case is from the defendant's perspective, nothing's done timely, and there's just wrong. There's just wrong rules of law. Everything they're even defending with is wrong. And like I said, they're in default with an amount certain, and the amount certain, you can leave that to the clerk to sign in a judgment. Although I've never asked the clerk, but I have asked for the default judgment. And like I say, there's an amount certain, and I know amount certain is one of the criteria, and that would be $1 million. And then also, it's against the law in North Carolina for a safety figure to taint a child's perspective of what a safety figure is supposed to be. At the time, my son was 4 years old, and when all this went on, there were 6 cop cars that went over there, or troopers, that beat up my daddy. He's a 73-year-old, 100% disabled Vietnam veteran, and that case is also pending, the FBI's involvement. But out of all them 6 cop cars, all the videos disappeared, except for one. And the one video that didn't disappear is not the arresting officer's video, and it's not the transport car's video. It's one of the other videos because it showed absolutely nothing. The other one, and therefore, the internal affairs, everybody was aware of this going into litigation. These videos shouldn't have been deleted, and that's why they saved That's why they saved the one random car that shows nothing's video. That shows they knew it was going to be in litigation. They wouldn't have saved that video. It was timed out for 90 days. Like they're claiming the arresting officer's car video did. They say it timed out in 90 days. Well, that to me shows a cover-up within the Highway Patrol. And Brent Snutherly is the Internal Affairs. He's been aware the entire time. And these troopers have never left the road. Like I said, there's just a lot of bad policy all the way around. And there's a bad concept of what the people of North Carolina are to the folks in charge. I mean, I'm a simple. I grew up on a farm. I live on a farm. I'm out in the country. This entire case was blowed off from the beginning, and therefore like I said, the entire case is negligent as far as the state's concerned. In my opinion, or even my opinion by rule. And like I said, that's really, like I said, that's about what I've got as far as their two motions, Your Honor. Oh, he mentioned the 3-year statute of limitations. Conspiracy goes to the last event. Basically, it's almost like I write the rules as far as conspiracy law. It goes to the last event. I can add claimants, or I can add defendants when I want to. I can bring in more evidence whenever I want to. I've been transparent the entire time. I allowed the Department of Justice into my computer. It's been probably 4 months ago or 5. I've been 100% transparent. They know when I go to sleep at night. They know everything. They know everything about me. Now, like I say, this has jurisdiction in the Industrial Commission. I know it's a rarity and it's an unusual case for the Industrial Commission. Like I said, it's normally it's dealing with, workers' comp or something. But this isn't. The main reason I done this is because I knew what would happen if I put this in Lincoln County, and I wanted it to go to Raleigh. I said the Department of Justice needed this case, and that's really, like I said, that's okay. There's one more thing. Rasco versus State. In that case has been ruled on by the Supreme Court that the handcuffs being put on negligently. It is an Tort Claims Act. So the Rasco versus State that totally covers beyond the untimeliness of the defendants. That covers everything that they've said, really. That's pretty much all. Thank you, Your Honor.
All right. Thank you very much. So what I'm gonna do now is, I'm gonna take this under advisement, and I will notify the parties just in the next few days, in less than a week, as to what my decision is on this. If, of course, if I grant the defendant's motion, then the case is dismissed and we can take whatever appeal we want to from that or however we like. If I don't grant the defendant's motions, then the case, of course, goes on. We'll have to come up with a discovery scheduling order and move the case down the line that way. So I will contact you by email in the next week and give you my decision on this case. Do either of you want to get a transcript of today's motion? Just go ahead and take care of that.
You could send me one, sir, if you wouldn't mind.
Well, you'll have to make arrangements with the court reporter to do that.
Okay. Well, it's recorded anyway. I've pretty much got it anyhow. It's really no big deal.
Okay, Mr. Brown?
No, we'll hold off on ordering the transcript.
Okay. All right. And with that, I'm gonna stop my recording here. And that'll take care of us for today.
Thank you, Mr.
I
Howard.
appreciate your
Thank you,
cooperation.
Thank you, Mr. Brown.
Thank you. Have a good day.
Thank y'all.
All right. Mm-hmm.